We're good to go? Yep. Okay, welcome everybody. Good morning, afternoon, lunch. So, welcome. Thank you so much for joining me today. We are going to discuss estate planning for homeowners, and I really want to focus in on trust. So, before we get started, of course, I got to give you a legal disclaimer. So, this is not legal advice. In order to give you legal advice, you need to become a client, or if you are a former client, you need to become a current client, meet with us, sign a fee agreement, and all that jazz. But for today, this is just for educational purposes only. So we want to focus on homeownership and trust. And I'll go over a little bit more information about trust and trust alternatives when we get further into the workshop. But again, thank you so much for joining me. Super excited to meet everybody, get your your questions answered, and we will go from there. So just some housekeeping rules and some housekeeping also. If there's any type of glitches, because obviously this is the internet and we're using electricity, so if there's any glitches or anything, don't panic. We will send you a recording of this. If my internet goes out, electric goes out or whatever, don't panic. I can record another workshop for you and get that emailed to you. So any problems or questions, I do have my contact information behind me. You can call us, you can text us, you can email us, go to our website. So I do want to save the question and answers last for this. I hate to jump back and forth between questions, so I will save those for last. I also have a list of questions that a lot of clients ask me, so I got those ready for us, and we'll hit those towards the end. So who am I? My name is Amy. I am a real estate attorney. I do estate planning and probate, and I have my real estate license. So I also help clients buy, invest, and sell real estate. So I am all things real estate. It's my wheelhouse. It's my thing. I love it. I love estate planning. And of course, with estate planning comes probate, and I'll explain how this all kind of fits together as we get further into the workshop. Before you guys tune to the workshop, we did email you some forms that you guys can fill out on your own. I'll go over this towards the end as well. This information is just some basic information to get your estate planning started, or just kind of look at it and see what all that entails. So this will help get you started. I'll go over this later towards the end of the workshop. It's straightforward, it's easy, nothing complex, but I'll explain that a little bit later as well. So I'm ready to get started. I'm sure everybody else is. For one of my goals for 2025 was to create webinars or workshops for clients. I believe there's not enough information out there for the community, our clients, or past clients. They just don't know a lot about estate planning. You don't learn about it in high school and school. You don't learn about it in college. So I want to provide more information out there to current clients, past clients, future clients, the community, especially with home ownership. The majority of my clients do own houses. So a lot of times with my clients, the house is their most valuable asset. So why are we not focusing on that and making sure that we preserve the asset or get it transferred to your beneficiaries without probate court? So, but that's why I want to focus a lot on home ownership today, is a lot of my clients do own some type of property or house, obviously. So let's get started. So estate planning. Why do we care about estate planning? Who cares about estate planning, right? Why should I care? So we all have stuff. So I have stuff here, right? We all have stuff. So when I pass away, where does my stuff go? Where does it go? So if you don't tell us where this stuff goes, then it's up to attorneys and probate court to figure out where this stuff goes. All stuff has some kind of value. So when somebody passes, okay, what do we do with this stuff? So you need to create a plan to tell us where your stuff goes. If you don't, then we have to get an attorney. We have to figure out and go by the laws in the state of Ohio, and the state of Ohio tells us where your stuff goes. That's why estate planning is important. If you don't have any of it, now we're in court, now we're in conflict. So the whole point of estate planning is keeping your family out of court and out of conflict. I can do a whole nother webinar and workshop on probate court. It's a lot of time, it's a lot of money. You need an attorney, there's attorney's fees, court cost, and it's very, very, very slow sometimes. I have some cases that have lasted a few years now. The court does not care about your family, doesn't care about your situation. They don't. The docket is extremely busy and they don't care. So we want to make sure we keep your family out of court and out of conflict. That's the whole point of estate planning. The other thing about estate planning is there's so many different estate planning tools, it will make your head spin. That's why it's important to hire a professional to figure out, okay, what is the best situation for me? At our office, we offer different estate planning packages. They're budget friendly, they're flexible with your life. So there's so many different tools, but like I said, today I'm going to focus on home ownership and trust, and I'll touch in some other estate planning tools that we also do here, but we'll keep it simple, we'll keep it straightforward for you. So I got my notes here, and what exactly is a trust? So a trust is an entity that we create. The whole purpose of the trust is when I pass away, where does my stuff go? So within your trust, you tell us where your stuff goes, when, where, why, and how. So just like with a business, somebody wants to start a business, start an LLC, the whole purpose of the LLC is to operate a business or an incorporation. The whole idea is to operate something. So instead of an LLC, we create a trust. A trust is specific for when I pass, where does my stuff go? With the LLC, the purpose is to run a business and some tax, some tax issues or something that's a little bit different. So today we're focusing on trust and what it is. We set up, it's almost like, I tell clients, it's almost like a contract with yourself. So it's a contract of, okay, when I pass away, this is what my wishes are. This goes to X, Y, and Z. We name a trustee, and then we name a successor trustee. So the idea is that your trust is going to outlive you because your trust is an entity that we created. So it's going to outlive you. And then your successor trustee steps into your shoes, and then the successor trustee distributes your assets according to your wishes. There's so many different types of trust. So again, it's important to talk to a professional to figure out what type of trust works best for you. I mostly do, and the most popular trust that we work on is a living trust. It's a revocable living trust. There's other different types of trust, but it just depends upon what the client's needs and goals are. With a living trust, I always tell clients it's just like living with you. It lives and breathes with you. You can sell stuff, you can transfer stuff, you can do all kinds of stuff with a living revocable trust, and you can revoke it. So maybe you change your mind. Maybe there's the family dynamics have changed or something. You can always revoke it, update it, change it all you want. We do a lot of trust updates. Some people change their mind. They don't want that person to be the successor trustee. They want somebody else to do it. Or maybe somebody passed away and they just need to update it. So that's what's really great about a living revocable trust. It's flexible with your life. It will work with your life. There's other types of trusts that are not like that. I can have a whole nother webinar on the types of trust. We don't have enough time. So that's another webinar, another workshop for another day. Again, the phone number is up here behind me, so you guys can call us with any questions or text us with any questions. We are happy to help you out. So moving along, why your home needs a trust. So when it comes to real estate, your house, your physical land, your house, it's titled a certain way. We have to figure out how it is titled. I ask clients the question of, do you own it by yourself, co-ownership, joint owners, what is it? And 9 times out of 10, they can't really answer my question. So I have to do my own little research to figure out, how is this real estate titled? Your house is a specific title. It's located at the county recorder's office. And I don't know if I've ever met a client that knew what the county recorder's office does. And that's perfectly fine. That's why we have professionals like me to explain what the county recorder's does. Amongst other things, the one thing it does do how I work with the recorder's office is that the copy of your real estate is at the recorder's office. So if you ever need a copy of your deed, you can call them up, you can go on their website, you can get a copy of your deed. They charge you a couple bucks to get a copy, but you can get a copy. Some counties you can view deeds online. Some counties you can't. Geauga County, as of right now, I don't think you can view it yet online. So we have to physically go down to the recorder's office and get a copy. But every county has their own recorder's office. So where your real estate, whatever county your real estate is located in, you can get a copy of your deed. And if clients need help with that, we can always help clients get copies of deeds. It's not a big deal at all. It's public record. But we pull the deed, we see how it's titled. So why do you need a trust? Because we need to know where your house is going to go when you pass away. If the house is not owned by the trust, okay, does the house have a beneficiary? Do we know who the beneficiary is? And a lot of times clients don't know any of this. So we got to do a little bit of research, a little bit of digging. It's pretty simple, it's straightforward, it's nothing complex. I just don't think clients, have enough knowledge or experience like professionals do to realize, okay, this is what we need to do. This is the information that we need. Not a big deal, but we pull the deed and we see how it is. So if your house is owned by your trust, we don't need probate court because the terms of your trust control how your house will be transferred. Will it be sold? Will it be given to so-and-so? It will lay out the terms and conditions of who the beneficiaries are. Now, if your house is not owned by a trust, there's a couple trust alternatives. There are clients that, can't afford a trust. That's okay. There's so many different estate planning tools. So another trust alternative would be a transfer on death deed. I tell clients, it's just a beneficiary deed to your house. It's very simple, straightforward. Another one that I've done, a handful I've done recently is a quitclaim deed with a life estate. But all of these are they need to be custom tailored to the client. So I'm naming a few alternatives. That doesn't mean it's going to apply to your situation. But another one I've done this a handful of times where you quitclaim deed to whoever you want to go to, a loved one, spouse or whatever, and then you reserve a life estate. That's another alternative, but there's other different estate planning tools, but those are the most common: trust, transfer on death, life estate. But again, it just depends upon what your family's goals are, your needs are. It all just kind of depends. So that's, again, it's another reason to consult a professional so you know all the terms and conditions and plus and minuses, pros and cons of which estate planning tool that you decide to pick. So if you decide to pick a trust and you want to transfer your house into the trust, it's pretty straightforward. We deed the house from the individual's name to the trust. So that way the trust owns your house, you're the trustee, you name a backup trustee. You can sell it, you can lease it, it doesn't matter. So long as it's a living, revocable trust, you're good to go. So that's why your house needs a trust. It needs some kind of estate planning. Next topic is, how does a trust help you avoid probate court? So we don't need probate court because your house is owned by the trust. The trust tells us what's going to happen and what's going on. We don't need probate court for that. We need probate court for, we don't need that. So we go to probate court when there's no estate planning, or the estate planning wasn't done right, or there's conflict, or there's some kind of contest, something needs to be contested. So that's why we go to probate court. We go to probate court because we need a court order to transfer the assets or to sell the assets, because a person who has passed away can no longer sign stuff, can no longer transfer things. So we have to have court orders to do that. So a trust helps with that because the trust owns your house. So then the successor trustee steps in your shoes and looks at the trust and determines, okay, this is what we need to do, don't do, and all of that. So that's how a trust helps avoid probate court. If you have a trust, you don't really need probate court, which is fantastic. With a trust, it's a private contract amongst yourselves or your family, and we don't run and file it with probate court. We want to keep that as private as possible. There's exceptions to every single rule, but the general idea is, I have a trust, I'm going to keep it private. We don't need to file it in probate court. It's none of anybody's business. The court usually does not try to get involved with trust, because the whole point is, we don't need probate court. We'll deal with it amongst ourselves because we have our trust. There's also trust alternatives that I talked about. We don't need probate court for them either. And I could probably do another workshop on trust alternatives as well, because those are those there's additional information with those. But estate planning, the whole idea is we don't need probate court. The next topic we can go over is the um, most common mistakes homeowners make. And I have a whole list of the mistakes that I see that clients have done or have questions about. So I will go over my list. I have my questions here. So just yesterday, I did a consultation with a client. She's like, I'm just so busy. I'm so busy. I don't have time for estate planning. And we live busy lives. I get it. But that's why we hire a professional. We make it very simple and easy on our clients. We're very flexible with scheduling things. You know, we can do Zoom calls, we can do a phone call consultation. Very simple, very easy. You hire us to make it quick and easy on you. So I don't want anybody to ever feel like estate planning is so hard. I don't understand it. I don't get it. I don't want clients to ever think that. It can be very simple and very straightforward. So I know she was a busy person, but we're here to help her and to streamline it. And it's very simple, but we do have to physically meet in the office at least once to sign the paperwork. So as of right now, estate planning has to be physically signed. So just keep that in mind, but we have to at least meet with clients at least once in the office for estate planning to get all the signatures in place. Another mistake that I hear a lot is, my dad said that the house needs to go to my brother, or my mom wanted that lamp to go to my cousin. If it's not in writing, then it never happens. And I know a lot of people say, verbally their wishes or, Joe Schmo should have this. If it's not in writing, it didn't happen. And I get this all the time. My mom said that I'm supposed to get that lamp, not her. If it's not in writing, I can't help you. If your mom's told you one thing and your will says something else, or your trust says something else, verbal is not good enough. It has to be in writing. Estate planning has to have a specific format or it's not valid. And I'll get into the other mistakes too, just handwriting something on a piece of paper is not enough for estate planning. It's got to be witnessed. We always try to notarize our documents as well. So there's a whole formatting that needs to take place. So just because somebody verbally said something doesn't make it valid. There's exceptions to every rule, but that's the general rule. What I tell clients is if it's not in writing, we have to look at what's in writing. If it's not in writing, I really can't help you. And that goes back to home ownership too, and estate planning for homes. Everything needs to be recorded when it comes to physical real estate. If there is trust, there's specific trust forms that need to be filed at the recorder's office. If you do any type of trust alternatives for your house, it has to be in writing and it has to be recorded. And I just tell people and tell clients, if it's not in writing and not recorded at the recorder's office, yikes, it probably didn't happen. So at our office, we always triple check to make sure everything is recorded at the recorder's office. So it's very, very, very important. Another mistake is not updating your estate planning. So if you change your mind or if somebody passes before you and then we have a bunch of deceased people on the paperwork as beneficiaries, we have problems. I had a case where there was a trust and he didn't update the trust and a bunch of the trust beneficiaries passed away before him. So now what do we do? So it's a big mess, and now we're in court because we have to figure out who the next of kin is and what their estate planning was. So please keep it updated. We offer free consultations every single year to our clients. A handful of my consultations is just glancing at clients' estate planning paperwork just to make sure it's updated. That's all. And just to update estate planning, it's very simple, very straightforward. I don't want anybody to ever feel overwhelmed or it's not possible. It's very simple, very easy, but please keep it updated. If not, We're in probate court trying to figure out who's the next of kin of who. It can get messy very, very fast. So please keep it updated. Again, if you have any questions, our phone number is right here. Call us, text us. I have no problems answering anybody's questions about updates. With trust paperwork, we amend a lot of the trust paperwork. When you amend trust paperwork, that has to be in a specific format as well. But it's easy to make corrections and updates to trust as well. It's not overwhelming. It's not daunting. Don't feel that way at all. Let's see what else. Oh, another mistake that I see is with clients is disinheriting somebody. I do get a handful of estate planning where people want to disinherit somebody that needs to be in writing. We can't just magically pretend this person doesn't exist. It has to be in writing. So if you want to disinherit a spouse, disinherit a child, it has to be in writing. It has to be in your estate plan. If you just magically leave them out, the law says if they're just magically left out, it's assumed that they're going to inherit. So I try to make that crystal clear with my clients. If you do want to disinherit somebody, it has to be in the paperwork. If not, they are going to inherit. And that's not keeping your family out of court and out of conflict. So if you don't want Joe Schmo to get your stuff, we have to put that in the paperwork. So please just keep that in mind. And I talked about the trust and the trust alternatives. And like I said, there's so many different estate planning tools that we can use. That's why when at our consultations, we figure out, okay, what's the client's assets, what's their goals, what estate planning tools would work best for them. And we offer different estate planning packages at our office, budget friendly, so you can always schedule a consultation with us to see what we have to offer. Let's see what we got here. I know we're at 21 minutes.
Amy, we do have one question.
Yeah.
Does your home need to be paid off before putting it in a trust?
So if there is a lien or mortgage against it, what I advise clients is to contact the mortgage holder. Just give them a heads up. And then once they give the mortgage company a heads up, then we transfer the house into the trust. But always, always, always make sure the mortgage company knows. And they usually want a copy of the deed or a memorandum or something of a trust. So I've done that a handful of times where I've emailed it to the mortgage company and then they gave us the okay and then we transferred it into the trust. Like I said, I know we got a few more minutes. I'm trying to see the most. Property in another state. I could probably go on and on forever, but property in another state, obviously different states have different laws. And that's why it's good to have a trust because all of the property can be held in one trust. So we have transfer on deaths here, the TODs here. Pennsylvania does not. So that would be an example. And I had this situation happen. If you own property out in Pennsylvania, they don't have transfer on deaths, but we do. So we can actually create a trust and have the trust hold multiple properties from different states. But again, everybody's situation is different. Everybody's needs are different. So I'd have to get a little more information on the different states. And we usually contact an attorney that's licensed there just to double check everything. But that's like another example of a trust and what we've done. Do you want to go to the questions or what would you like to do?
It looks like that was the only one that was put in there so far.
Okay. And I'm sorry, go ahead.
I didn't know if you know of any other hot questions that usually come up.
Yes, hot questions. So, what's the difference between a will and a trust? One of the biggest misconceptions is that I have a will, so therefore I don't need probate court. That's actually not true. Your will is specific for probate court. A handful of my probate cases are where they owned real estate and they just did a will. The will is just a catch-all document, just in case your estate plan missed something or you forgot about something. You will be surprised at all the little things that clients forget about. I forgot about a life insurance policy. I didn't think it was valid anymore. Then you get a letter in the mail a year later that, oh, You know, there's a life insurance policy here, but now there's no beneficiary. Then we need probate court, but the will is specific for probate court. The trust is not made for probate court. The trust is made to stay out of court, out of conflict. It's none of the court's business. It's none of anybody's business. But the will becomes a public document. When we do draft trust, we do a pour over will. A pour over will is specific for a trust. And again, that will and just a regular will, it does the same thing. It's just a catch-all document. So if somebody forgot, I bought a new car and I forgot to title it into the trust. It's okay. The will's for probate court. We can get it poured over into the trust. But that's one of the biggest misconceptions is I have a will. I don't need probate court. That's not true. Probate court, the will is specific for probate court. And then in the will, you lay out your wishes. You have your executor and backup executor.
Amy, we got one more question.
Yeah.
Are there any things you cannot put into a trust?
You can put anything that you want in a trust. It's your trust. One of the trusts, I didn't draft the trust, but one of the trusts I've seen recently is somebody needed to take care of her cat. So you can actually put caretaker language in there for pets as well. You can put anything in trust. You can put pens, papers. And another question I got from a client recently was, is there like a limit? Like, is there a certain like money amount that I need in order to create a trust? No, you can, like I said, I can fund it with a pen. I can fund it with, you know, my cell phone, $1. The trust has to be funded though. If the trust is not funded, it's not valid. But when we create the trust paperwork, we also add catch-in language, you know, the contents of my house, the contents of the barn, all tools, all vehicles. We always try to put catch-all language in everything so it catches everything and the trust is properly funded. Is there another question?
Not at this time.
Another mistake that clients make is when they try to draft their own estate planning. When I look at somebody's estate planning, I can tell immediately if it's done by themselves, if they did it on the computer and they didn't consult a professional. So an example is a lady who passed away. This is a probate case I had. A lady passed away and she hand wrote her will. The problem was we couldn't read her handwriting. So it was very difficult to try to figure out who was what and where, but luckily all the siblings got along and we figured it out, but we needed probate court because we couldn't read it. Like I said, there's also certain formats that you need to follow with estate planning. When people do them themselves, they don't always follow that format. Another mistake I saw was somebody that did estate planning online by themselves was they were a beneficiary and also a witness. You really don't want to do that. You want to make sure that you have witnesses that are disinterested is what we talk about. Can you be a beneficiary and also be a witness? You can, but you don't want to do that because your benefit to the will or benefit to the trust can be reduced. You just don't want to do that. But somebody that did their estate planning, they had their, it's a whole thing. That was not a good place to be, but so please do not be a beneficiary and also a witness on there. You need 2 disinterested witnesses, and we also at our office like to notarize documents as well. But like there are also a lot of other online that says like it's Ohio specific, and you can go just Google it and get specific Ohio estate planning documents. That's not true, and I've seen them and I can spot them immediately. It is not custom tailored to your situation. All the AI and Googles out there do not practice probate court. I know all the pitfalls of probate court. I know a lot of the mistakes that AI and Google is not going to catch. Yes, Google, draft me a will. Click, click, click. Yeah, they'll draft your will, but they don't know all the pitfalls and how to avoid those pitfalls. So speaking on that, another hangup that I get from the estate planning is we need a backup person. So if you have an executor, we need a backup person. You have a beneficiary. We need a backup situation to the beneficiary. So I get a lot of that. And real quick before we go, I'll probably go a few minutes over, but going over the
We got
hand.
one more question.
I'm sorry.
Sorry. We got one more. Can your trust be sued?
Yeah, it's so the trust is a entity that we create. You can't sue a trust, you sue the trustee. So if you feel the trustee is mishandling the assets, commingling assets, you can ask the probate court to have a trustee removed. Yes, but you don't sue a trust. You sue the trustee. And just quick about the handout that we emailed everybody, just to quickly go over it. Like I said, it's pretty straightforward. Any questions, our phone number is right there, or you can text us, call us, email us, whatever works for you. But basic information, and a lot of clients don't have this and they don't know what they need to start their estate planning. We need your information. I know it seems pretty straightforward, but a lot of clients just don't even know. So we need your information, your name, your address. A lot of people don't know their own phone number anymore because it's automatically programmed into their cell phone. So make sure you dig that out and get that. We also need to know who's your next of kin. Are you married? What's your spouse's name? We need names, addresses, dates of birth. When it comes to your children, we need names, addresses, dates of birth. I have a lot of clients that just say, "Oh, my son just lives right down the road," but we got to have their contact information because all this information gets put into the estate planning that we draft. So that's the first page on the handout. The second page is going to ask about trust. Do you already have a trust? Are you interested in trust? If you do have a trust, I always advise clients to please review it. Make sure it's updated. It's very simple to amend or update any type of trust. It's fairly simple, but again, there's certain formats that we need to follow to make sure that your amendments or changes are valid. I'm going to ask you about trust. It's going to ask you about the beneficiaries, their information. We need to know what your wishes are. Do you want everything to go to charity? Do you want something to go to charity, but the rest go to your son? We need to know where all of your stuff goes. Some clients don't know, so I help kind of guide them of examples that I've done in the past. And then the client can choose, okay, this is what I want, this is what I don't want, this is what I have questions about. The second page is also going to talk about guardianships and minor children. Just real quick, and I could probably do a whole other workshop on this. We cannot give money or property to minors. You have to be 18 in order to inherit in the state of Ohio. So if we have a minor inheriting property, we need to set up a trust to do a guardianship with that. But that's a whole nother webinar for a whole nother day. But just kind of keep that in the back of your mind if you have minor children. Who's going to take care of them? Where's the property going to go if they're still a minor? The next couple of questions going to ask you is, that usually you're your own trustee of your trust, but then we need a backup person. What's their name, address, phone number? It can be a loved one. It can be next of kin. It can be whoever you want it to be. Same with your will or pour over will, executor, backup executor. We need a backup situation. We need a backup person just in case. I was going to ask you about that. I was going to ask you about some power of attorneys. I don't have enough time today for power of attorneys. I could probably make another workshop for that as well. That's a different estate planning tool. Today, we're focused on home ownership and trust. Power of attorneys will have to be another workshop for another day. And it's going to ask you if there's any other miscellaneous questions that you have or situations that you have for your estate planning. So that is pretty much everything in a nutshell. I hope I covered everything. Again, our contact information is right here. We're more than happy to help. So yeah, just don't be afraid to reach out for any questions, any free consultations. Let us know. And hopefully did I get everybody's answer or any questions answered? I hope.
Yeah, we're good.
Okay. All right. Thank you. And reach out with any questions. Thank you.
Thank you, Amy.